Hello everyone. My topic for today is Order 18 and 19. We'll first go through an overview of Order 18. After the adjournment, the court fixes a date for hearing of the suit. Hello, am I audible? Hello? Yeah. After adjournment, the court fixes a date for which brings us to Order 18. In hearing of a civil case, it is the plaintiff who has the right to begin the hearing of the suit. Under this order, the rooms for examining the witnesses been also been included. Order 18, Rule 1 talks about states that the plaintiff has the right to begin first unless the defendant admits to the fact alleged by the plaintiff and contends that either on the point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any relief, any part of the relief which he seeks, in which case the defendant has the right to begin first. Similarly, if on the issue or issues of fact, the burden of proof is on the defendant. It is the defendant who has the right to begin in a suit for restitution of conjugal rights, where the marriage is admitted by coercion and non-consent is pleaded, or in a suit where the defendant pleads minority. It is the defendant who has the right to begin first. Uh, in the case of Shraddhamani Panda versus Chintamani Panda 2018, the petition under Article 227 of the Constitution challenged the order by additional senior civil judge Puri, whereby the trial court allowed the plaintiff under Order 18, Rule 1 of CPC and directed the defendant to begin first. The defendant filed a written statement that said the property was renovated and developed by their father. The court, while relying on the case of Ramakrishna Mohanty versus Balakrishna Mohanty 2017, and on order 18, Rule 1 of CPC, held that the defendant should begin first only when the defendant leaves some evidence in proof of their case. The plaintiff shall be obliged to leave the evidence in rebuttal. Order 2 of Rule 2 talks about states the day on the day fixed for the hearing of a suit or any other day to which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence in support to the issue, which he is bound to prove. The other party then shall produce his evidence, if any, and then may address the court generally on the whole case. The party beginning may then reply generally on the whole case. Any party can address the argument orally in a case, or he can and conclude the oral arguments, and can also submit their arguments in written under distinct headings in support of his case to the court, and such written argument shall form part of the record. According to Rule 3B, a copy of such a written argument shall be provided to the other party. Rule 3C, no adjournment shall be granted for the purpose of solely filing the written argument unless the court, for any reason, gives the permission to do so. And Rule 3D, the court shall fix such time limit for oral arguments by either of the parties in a case as it thinks fit. Rule 3, in a case where there are several issues, the burden of proving some of such lies on the other party. The party beginning may, at his option, either produce his evidence on those issues or reserve it by the way of answering to the evidence produced by the other party. And at any at in the la- and in the latter case, the party beginning may produce evidence on those issues after other party has produced all his witnesses, and the other party may then reply specifically on the evidence so produced by by the party beginning. Uh, Rule 3A talks about party to appear before other witnesses, where a person himself wants to appear as a witness. He shall do so. He shall do so before any other witnesses has been witness have been examined on his behalf, unless the court, for some reason to be recorded, permits him to appear on his own as his own witness at a later stage. In Sanjay Dainik versus versus Gokulchand Govindlal, Govindlal, it was held that implicit in the statutory scheme is the rider that the normal rule may be deviated from only in exceptional circumstances and for some reason to be recorded, which must sustain judicial review. The legislative objective of bringing the statute rule 3A was to ensure that litigant should not be permitted to bid his time and to fill in lacunas or cover the loopholes after other witnesses have already been examined. And in this case, the court found it difficult to believe that the plaintiff has claimed to be suffering from various ailments to such an extent that he was not in a position to step into the witness box. Therefore, the court held that the order impugned militate against the object and intendment of Rule 3A, which was accordingly squashed. Moving on to Rule 4, recording of evidence by commissioner. In every case, the evidence of a witness of his examination in chief shall be given by affidavit, and copies therefore shall be supplied to both to the opposing party to the opposite party by the party who calls him for evidence, provided that there were that where documents are filed and the parties rely upon the documents, the proof and admissibility of such documents which are filed along with affidavit shall be subject to the orders of the court. Rule 3A, according to Rule 3A, the affidavit of evidence of all witnesses whose evidence is proposed to be led by a party shall be filed simultaneously by that party at the time directed in the first case management hearing. Rule 3B, a party shall not lead additional evidence by affidavit of any witness, including a witness who has already filed an affidavit, unless a sufficient cause is made out in an application uh, for that purpose, and an order giving reason and permitting such additional affidavit is passed by the court. Rule 3A states that a party shall, however, have the right to withdraw any of the affidavits so filed at any time prior to the commencement of cross-examination of that witness without any adverse interference being drawn based on such withdrawal, provided that the other party shall be entitled to tender as evidence and rely upon any admissions made in such withdrawn affidavit. The evidence, cross-examination, and re-examination of the witnesses in attendance, whose evidence, examination in chief by affidavit has been furnished to the court, shall be taken orally by a commissioner to be appointed by the court from amongst the panel of commissioners prepared for this purpose on the same day, provided that in interest of justice and for reason to be recorded in writing, the court may direct that the evidence of any witness shall be recorded by the court in the presence and under personal direction and superintendence of the judge. Rule 3, a commissioner shall be paid such sum for recording evidence as may be prescribed by the High Court. The amount payable to the commissioner under sub-rule 3 shall be paid by the court or by the parties uh, summoning the witness as may be prescribed by the High Court. Rule 5 talks about the district judge as the judge shall prepare a panel of commissioners to record the evidence under this rule. The commissioner shall record the evidence either in writing or mechanically in his presence and shall make a memorandum which shall be signed by him and the witness and submit the same to the court appointing such commissioner. Where any question put to the witness is objected by a party or his pleader, the commission and if the commissioner allows such question to be put to the witness, the commissioner shall take down the question and answer together with his decision. The provision of the provisions of Rule 16, 16A, 17, and 18 of Order 26, insofar as they are applicable, shall apply to this issue. Execution and return of such commission under this rule. According to the new amended Rule 4 of Order 26, requiring the parties to file examination in chief of their witness on an affidavit, caters to the convenience of the parties and is aimed at quick disposal of the cause, and it does not in any way run counter to the spirit of scheme of Order 26, Order 20, sorry 20, so Order 18, Rule 1, which only refers to the parties' right to begin. Recording of evidence on affidavit by commissioner, where the plaintiff has filed their evidence on affidavit by the way of examination in chief, even before cross-examination could commence, various objections were raised by opposite parties involving serious disputes, held that the same could not be resolved as at intervening stages, and it would be open to the court in course of cross-examination to deal with objections, as also evidence led on affidavit as to whether it is based on hearsay or otherwise. Moving on to Rule 5, how evidence shall be taken down in appealable cases. In a in case in a case in which appeal is allowed, the evidence of each witness shall be taken down in the language of the court in written or in presence and under the personal direction of the superintendent or of the judge, or from the dictation of the judge directly on a typewriter, or if the judge for some reason to be recorded so directs it to be recorded mechanically in the language of the court in presence of the judge. Rule 6, when deposition is to be interpreted, where the evidence is taken down in a language different from that in which it is given, and if the witness does not understand the language in which it is taken down, the evidence as taken down in writing shall be interpreted to him in the language in which it was given, so that he understands the statement that they made. The evidence of witness shall be taken orally in open court in presence and under the personal direction and superintendence of the judge. In case in which an appeal is allowed, the evidence of each witness shall be taken down in a language of the court. In language of the court. Moving on to Rule 7, evidence under Section 138. Evidence taken down under Section 138 shall be in the form prescribed by Rule 5 of this order and shall be read over and signed. And if an occasion may require interpreted and corrected if it is as if it were evidence taken down under that rule. As per Section 138, power of High Court to require evidence to be recorded in English. The High Court may, by notification in official gazette, direct with respect to any judge specified in notification or falling under a description set forth therein, that evidence in case in which an appeal is allowed shall be taken down by him in English language and in manner prescribed. Rule 2, rule Sub-rule 2 talks about where a judge is prevented by any sufficient reason from complying with a direction under subsection 1, he shall record the reason and and cause the evidence to be taken down in writing from his dictation in the open court. Subsequently, Rule 8, memorandum when evidence not taken down by the judge, where the evidence is not taken down in writing by the judge or from his dictation in the open court or recorded mechanically in his presence, he shall be bound as the examination of each witness proceeds to make a memorandum of the substance of what each witness disposes, and such memorandum shall be written and signed by the judge and shall form the part of the record. Rule 19, when evidence may not be taken in English, where evidence is not taken is where English is not the language of the court, but all the parties to the suit who appear in person and the pleaders of such parties as appear pleaders of such parties do not object to having such evidence as is given in English being taken down in English, the judge may so take it down or cause it to be taken down. Where evidence is not taken in English, but all the parties who appear in person and the leaders of such parties do not object for having such witness to be taken down in English, the court may take it down or cause it to be taken down. Moving on to Rule 10. Rule 10 states talks about any particular question and answer may be taken down. The court may, on its own motion or on the application of any party or his pleader, take down any particular question and answer or any objection to any question if there appears to be any special reason for doing so. Rule 11, question objected to and allowed by the court, where a question is put to a witness by the party or its pleader, and the other party objects to such question, but the court allows the same to be put to the witness. The judge shall take down the question, the answer and the objection, and the name of the person making it, together with the decision of the court. Rule 12, remarks on demeanor of the witnesses. The court may record such remarks as it thinks material respecting the demeanor of any witness while under examination. Moving on to Rule 13, memorandum of evidence in unappealable cases. In a case in which an appeal is not allowed, it shall not be necessary to take down or dictate or record the evidence of every witness at length, but the judge, as the examination of each witness proceed, shall make in writing or dictate directly on the typewriter or cause it to be mechanically recorded a memorandum of the substance of what the witness deposes, and such memorandum shall be signed by the judge or otherwise authenticated and shall form part of the record. In unappealable cases, it is not necessary to take down the evidence of the witness in writing. In other cases, also where the evidence is not taken down in writing by the judge or from dictation in open court or recorded mechanically in his presence, he shall be bound to make a memorandum of substance of what each witness deposes. Such memorandum shall be written and signed by the court by the judge and shall form a part of the record. Moving on to Rule 15, power to deal with evidence taken down before another judge. Where a judge is prevented by death, transfer, or other causes from concluding the trial of the suit, his successor may deal with any evidence or memorandum taken down or made under the foregoing rule as if such evidence or memorandum has been taken down or made by him or under his direction, under the said rule and under the said rules, and may proceed with the suit from the stage at which his predecessor has left it. Rule 2 talks about Sub rule 2 talks about states that sub rule 1 shall, so far as they are applicable, be deemed to apply to evidence taken in suit transfer under section 24. Under section 24, section 24 state that High Court or District Court can transfer and withdraw any case an application of any of the parties at any stage of the suit, whether on pending or appeal proceedings. Rule 16. Rule 16, power to examine witnesses immediately. Where a witness is about to leave the jurisdiction of the court or other sufficient cause is shown to the satisfaction of the court, why his evidence should be taken immediately. The court may, upon application of from any of the party or from the witnesses at any time after the institution of the suit, take the evidence of such a witness in manner herein before provided. Where such evidence is not taken forthwith and in the presence of the parties, such notice as the court thinks sufficient of the day fixed for the examination shall be given to the parties. The evidence so taken shall be read over with to the witnesses, and if he admits it to be correct, it shall be signed by him, and the judge shall, if necessary, correct the same and shall sign it, and may then be read at any hearing of the suit. Rule 17.
Hi, Aboli.
Court may
May I interfere you for a minute, please? Misbah this
Yes,
side. Aboli, you need not to go through each and every line of the rules and sections. Whatever you feel important, you can tell them directly. For example, in rule 1, which is who has a right to begin, how can one initiate, and third one, like a few things that I have remembered or recalled that I mentioned, that you can give a brief synopsis or a written argument at the time of a final hearing of the matter, or even whatever you take the marginal note for your reference, and whatever you feel important, you speak your mind. There is no issue in that. You need not to go through every line of the rules. Make it more interactive, and whatever you feel important, you can communicate, or if it has any practical implication, you can explain to them, to your other fellows. Okay. Thank you.
Okay. Moving on to rule 17. So this rule basically talks about how the court at any stage of the suit recall any witness who has already been examined and put questions to him as the court thinks fit. Rule 18 and Rule 19. Rule 18 basically talks about the court's power to inspect. The court may at any stage of the suit inspect any property or a thing that may materially concern the case, or if any question arises, and where the court inspects such relevant facts as soon as it as may be practicable, and make a memorandum of any relevant facts observed at such inspection, and such memorandum shall form part of the record. Rule 19 talks about power to get statements recorded on commission. Notwithstanding anything contained in these rules, the court may examine the witnesses in open court, direct their statements to be recorded on commission under Rule 4A of Order 26. Order 26, Rule 4A basically states that person whose examination commission may issue, any court may in any suit issue a commission for examination of uh, examination on intercat intercategories or otherwise of any person resident beyond the local limit of its jurisdiction. This basically talks about when a commission can be appointed for examining of a witness. Moving on to Order 19. Order 19, pro, in order to prove the fact
Hi, Boli.
examination. So this basically, yes, sir.
May I interfere for a minute, please?
Yes, sir.
Basically, I want to add something in Order 18
Yes,
that
sir.
we have seen in our experiences while doing the cases in civil, while doing civil cases and recovery of money suits. First one is the right to begin, and
Yes, sir.
second one is the statement and production of evidence. Right to begin, if you want to explain it, you can explain it, and otherwise I can give you one example of my cases of recovery of money suit.
You can,
Please, if you
you
want to
can.
put light on right to begin, it is more related to evidence act as well, but
So,
we can
right,
put light on it. Right to begin
yeah, right to begin.
during examination of witness and hearing of suit.
Yes. So the right to begin, a plaintiff has the right to begin unless the defendant already admits to the alleged facts on point of law or any other fact, then the defendant has the right to begin, and if not, then the plaintiff can proceed forward.
What does it mean? It means that we have two cases. First one, the any person who begins the case or who files claim has to prove something, that he has a claim, and that person has a right to begin, for example by filing suit, by leading evidences. At the same time, the right to begin also comes to the defendant when we say that the complaint or the suit is to be rejected at a threshold. Suit is not maintainable. Basically, if we are challenging the jurisdiction of the tribunal or the jurisdiction of the court, or we are filing name deletion application, or we are filing rejection of the plea, that is 711 application, that in that case we have the defendant got the right to begin. So it changes depending on who has the onus of proof.
Yes, sir.
Okay, please go ahead.
Okay. So Order 19 basically talks about affidavits. Rule 3 of this order specifies matters only to which the affidavit shall be limited to. Rule 1, power to order any point to be proved by an affidavit. So this rule specifically states that the court may at any time, for any at any time, for any sufficient reason, order any particular fact or facts to be proved by an affidavit. The affidavit is a voluntary sworn statement under which oath is used as verification for various purposes. The state is witnessed and signed by a notary, public, or other official authorized to do so. Once signed, the document is legally binding, and the person signing it is subjected to charge with perjury if the affidavit contains any false information. So this rule basically talks about verifying certain facts or certain facts as so directed by the court. Rule 2, power to order attendance of deponent for cross-examination upon application of evidence. Upon any application of evidence may be given by affidavit, but the court may, at the insistence of any of either of the parties, order attendance for cross-examination of the deponent. Such attendance shall be in court unless the deponent is exempt from personal appearance in the court or the court otherwise directs. Rule 3, matters to which affidavit shall be confined. So it shall be confined to such facts as the deponent is uh, able of his own knowledge to prove, except for interlocutory applications on which the statements of his belief may be admitted, provided that the grounds therefore are stated. So stated in the case of Sukhwinder Pal, Bipin Kumar, and others versus State of Punjab and others, the court held that under Article 32 of the Constitution, held that under Order 18, Rule 3 of the Code, it was incumbent upon the deponent to disclose the nature and the source of his knowledge and sufficient particulars. So it said that there should whilst making such statement, the source of his knowledge should be written down. So it cannot be just hearsay. Though his source should be very particular and significant. In a case where allegations in the petitions are not affirmed as aforesaid, it cannot be treated as supported by an affidavit as required by law. So that's it.
Thank you, Aboli. If anybody has any query or a question, please feel free to ask. And anybody who are eager to answer those questions can freely. किन्हीं को कोई क्वेश्चन पूछना है? I want to draw attention towards Rule 6 of Order 19. It is of a very practical importance. You can see each and everything which we do in our affidavit has been mentioned there. For example, everything should be given in a chronology with the relevant date and events that we need to mention in our affidavit. The facts which are based on our personal knowledge that we need to mention in affidavit, and the pleadings and the grounds we always mention in our affidavits that from paragraph so and so, this is based on a personal fact which I believe to be true or based on a legal advice from our counsel. Could you please go through the D, which is the statement in it made from the deponent's own knowledge and which are matter of information or a belief? Because we know the Section 3 of Evidence Act clearly says the affidavit is not an evidence under Section 3 of Evidence Act. It is mentioned the thing which is mentioned in affidavit is not an evidence. Could you please tell why? Why it is not an evidence? Because it is based on a personal knowledge and belief, which might be true and might not be true. And it is written in the affidavit that is to the best of my knowledge. And to the best of my knowledge and belief. It means it's not a fact from concrete fact which we can prove it. We can always say it is our belief system. It is what we perceive that is written in an affidavit. And subclause D of a Rule 6 subclause D and E is very important. You can write, it is a very important to write in an affidavit, otherwise it will be marked as a defective in a petition. When we file a petition in a registry, when they check the affidavit, they always go through it. That what are the paragraphs which are based on deponent's own knowledge, and what are the source and information of that belief. What is the source of information or what is the source of that belief? That is always written in the paragraph of a affidavit. And it is also that from which para, from para so to so, it is have the pages numbered consecutively as a separate document on several document contained in a file, divided into numbered paragraph. From paragraph this to this is based on my personal knowledge. From this to this is based on my personal belief, and from this to this is based on my legal advice which I believe to be true, and rest are my humble submissions and prayer. It is always written, and we need to specifically mention it, because sometimes when the cross examination is done, it is always you can, if that is not based on the personal knowledge, you need to answer it. If it is based on a personal knowledge or a belief, and we also write where that belief is derived from the record available from year dash to dash, we always mention it. For example, if a person is a director in a company and he file an affidavit, then he always write in affidavit that this fact is based on knowledge which I derive from the document. So it is always written in that format. And also the manner and nature of a cross examination always goes in that manner which is written in the affidavit. If I feel that thing has happened, this agreement has been executed in front of me, then I has to depose before it. If I say this agreement has been executed as I gathered from the document, then document will be referred. That is the thing that I need to bring to your notice under rule 6, sub rule 6. Okay, please go ahead. Anybody can ask any question. Thank you, Aboli. It has been very thorough, but it could have been made more interactive. Okay. Thank you.